Alejandro Montes de Ochaves.
Yes, sir.
Right here, bro.
All right,
Well, I
what's the
don't know
last
where
name?
they-
What letter does the last name start with?
Starts with an M. Montes. And then it's got a hyphen.
I found it.
Okay.
We are on the record in 2024 TR 3023, State of Kansas versus Alejandro Montes de Ochaves. Jared Regier for the state. The defendant appears in person and pro se. Oh, strike that. The defendant appears in person and by and through counsel, Darren Patterson. Mr. Patterson, how does your client wish to proceed?
Judge, just a brief summary in the case. This is a case where he was initially pro se, that it appears that at a previous hearing, when he was pro se, that he was entering pleas to the two charges that he had. After the plea was accepted, I wasn't there, so I'm not sure exactly what happened. But at some point after the plea was accepted, but during the same day, I think there was discussions where he then wanted to have an attorney and possibly withdraw his plea. I can tell the court after I was appointed, I did file such a motion to withdraw a plea. The state has now filed a response objecting to that. I've explained that to my client. I've also explained to him that because I was not at the hearing where all this occurred, I would be forced to ask for a transcript in order to be prepared to argue both the motion and reply. After discussing that with my client, he has asked me to withdraw the motion filed to allow him to withdraw his plea. He will not ask the court to withdraw the pleas. He does want to proceed to sentencing today and finalize the case.
So, Mr. Patterson, would that take us back to February 26, 25, at the hearing when he had waived his counsel and pled guilty to counts 1 and 2? He was fined $800 and 108 court costs with an 8-month underlying sentence. Count 2, $100 fine, 120 days underlying, with 12 months non-reporting probation.
And Judge, that would take us back to there, except that count one's. Okay, yes, that would take us right back to that position, Judge, where he is not wanting to withdraw his plea or sentencing.
All right. That being the case, then the court's orders of February 26, 2025 remain, and Mr. Montes, how much time are you going to need to pay all this money owed?
How much was the estimate altogether?
Let's go back over that. Count 1,
Your-
8.
And Your Honor,
Yes.
before the court proceeds further, the state would be requesting a formal pronouncement of sentence on the record for purposes of filing an appropriate journal entry. I do have notes in my file to indicate that at the February 26th date, the court did find the defendant guilty of counts 1 and 2. However, my notes are inconclusive as to whether or not the court formally proceeded to sentencing at that time.
Well, I have notes suggesting I did, but I will go back over those in case we didn't. Maybe
Thank you,
that
Your
was-
Honor.
Let me get these down again. 800, 8 months. Okay. At this time, having accepted the defendant's plea of guilty after waiver of counsel on counts 1 and 2, February 26, 2025, the defendant is sentenced to $800.
And I'm sorry, Judge, I apologize for interrupting. If,
Okay,
and again, I wasn't at that hearing. I don't have a
Right.
transcript yet. So if the plea is where we're at, then I think we're ready for arguments for sentencing. If the court hasn't
Oh.
announced sentencing yet.
okay, well, I think I have, but let's go ahead and get the transcript.
But, and my client doesn't want a transcript, but if we're at the point of arguing for sentence, I would have an argument. If the court believes that sentence has already been pronounced, then I think the sentence would just go into effect.
Okay, let me reread these notes. State indicates, it looks to me like he entered a plea. Okay, I'll just read them to you. Traffic 2/26/25, traffic docket, Judge Webster. State by J. Regier, ER for electronic recording. Defendant is present with court security. Defendant waives right to counsel verbally and appears to sign a waiver of counsel with court security. Defendant pleads guilty to counts 1 and 2. Count 1, $800 fine, 108 court costs, 8 months underlying sentence. Count 2, $100 fine, 120 days underlying, 12 months non-reporting probation. And then there are 4 stars pop up in the notes, like state indicates that the defendant's charges, they will be a habitual violator, and this will affect his license. This is stated after plea and finding of guilt. Judge will set over sentencing, so the defendant has time to speak with attorney. Defendant will need to fill out a court-appointed counsel application. Next hearing set April 21 at 9 a.m. Defendant to go through booking and processing, $2,500 OR bond. And then there are some other entries since then, like the 4/21 is when Attorney Patterson was appointed. So it could be that those fines were the ones recommended by the state. I cannot tell you whether those were actually made a sentence, because there's definitely an indication that says the judge will set over sentencing. So if I did impose it, apparently I decided to give it another chance, or those were recommendations that hadn't become the order. Counsel will take recommendations on how you want to proceed, whether we proceed with sentencing or we don't. But I could
Judge-
certainly go back without a transcript. I could go back and listen probably to the video.
And Judge, I would tell a court that given that those were the state's recommendations, the only modification or request I had different from that would be that, and I'll give my reasoning for it also, is that if he had an attorney at the outset of the case, I would have normally plea bargained it to just one charge and dismiss the other, reduces fines and costs. But of course, these are charges that have set fines and costs, so we don't really have a lot of wiggle room there. But also, I would have been requesting as part of the plea negotiation a 6-month sentence on count 1 rather than 8. So that would be the only request for modifying, is a 6-month controlling sentence. We'd ask the court though to adopt all the other recommendations of the state.
So you're asking only the 8 months be 6 months.
6 months, yes, Judge. That's it. No other modifications requested.
Well, sometimes the state or the court goes with 12 months. So Mr. Regier, what's your response to that?
Your Honor, the state does stand by its original recommendations. However, if counsel for the defense is arguing for a 6-month controlling sentence, the state is not opposed to that per se. However, the state would be recommending a reporting probation subject to all standard conditions if the court is prepared to proceed in that fashion.
And now I don't understand why that has happened. So I guess we would revert to our motions, I guess, and get a transcript.
Do we need a transcript, or can I just listen to the video and
I would have to
clarify.
listen to it also, Judge, in
Okay,
order
well,
to
that'd be fine. Jen,
understand.
let's ask Jen if Jen, can we just get a copy of the recording, or do we have to get a transcript? Or do you know? It may not be a question for you. I don't know.
I am unsure. Let me ask.
Okay.
Yeah, I have a breakout room with Mr. Regier, see if we just can't finish the case.
Okay. Well, you can't now because I just sent Jen on a mission.
I put them in a breakout room. I will do some testing as well.
All right, thank you.
Might go turn that down while we're on the breeze.
Mr. Nicholson, if you start your video, it will remind me to take up your case. If I see you, I don't want to make you wait any longer. Where's your client?
Your Honor, he's with me here in my office.
Oh, very good. All right. Well, when we get a free moment here, I want to go ahead and take that up.
Very good, thank you.
Thank you. Back on the record in 2024, TR 3023, State of Kansas versus Alejandro Montes de Ochaves. Montes. And all parties as before. Mr. Regier, have we anything else to say?
We've reached an
Mr.
agreement for sentencing recommendations, Judge.
And what is that?
Your Honor, pursuant to plea negotiations, the state is recommending the statutory minimum fine for counts 1 and 2 of $800 and $100 respectively. The state would further be recommending the imposition of court costs and the court make an appropriate determination on the issue of attorney's fees. The state is prepared to recommend a non-reporting probationary period of 12 months and a controlling sentence of 6 months with respect to count 1 and 120 days with respect to count 2. The state is not opposed to concurrent sentencing. State's understanding if the case does proceed to sentencing today, the defense would be formally withdrawing the motion pursuant to plea negotiations and journalizing the same.
That is all correct, Judge. We'd ask the court to adopt those recommendations. I can tell the court, looking at the current driver's license status of my client, he has one more thing to do to get his license back, and I do not believe this will cause habitual violator status based upon these pleas here today.
At this time, Mr. Montes, I'm going to impose the sentence of February 26, 2025. Count 1, $800. Count 2, $100. I'll go ahead and make your sentence 6 months on count 1 and 120 days on count 2 to run concurrent with each other. But you're also going to owe $250 in court-appointed attorney's fees because it looks like you do work. You're muted, deputy. Where do you work?
Road Saves Traffic Systems.
You'll have $250 of court-appointed attorney fees, $108 of court costs. It looks like that totals somewhere around $1,258. Can you pay that today, or do you need time?
Need time, probably give me another month, probably.
How much can you pay today?
700.
If you order 700 today, I'll make that a condition of your probation and order that you pay the balance within 30 days. You are to violate no laws, and I will grant a 12-month non-reporting probation. But again, your non-reporting probation is for 12 months. Conditions are violate no laws, pay $700 towards your fines and costs today, and pay the remainder within 30 days. Anything else, counsel?
No, Your Honor.
All right, then we're in recess. Mr. Montez is excused. And I'd like to go back to Mr. Nicholson for a moment. He's got his client here now. Mr. Rickoff, where are you? You're in the office?
Thank you, ma'am.
We are back on the record in 2024 CR 469, State of Kansas versus Matthew Rickoff. Please announce appearances.
Jeremy Gear on behalf of the state.
Brian Nicholson here with the defendant and who appears in person.
And he's charged with criminal damage to property.
All right, let's talk about that. The case of Alejandro Montes de Ochaves was a bit of a procedural puzzle before it settled into a straightforward resolution. Initially, there had been confusion over whether sentencing had already been pronounced. Back in February, when he waived counsel and pled guilty, his attorney, Darren Patterson, explained that a motion to withdraw plea had been filed, but his client now wanted to drop it and move forward. Judge Webster, ever careful about the record, walked through her notes and the timeline, even pausing to consider whether a transcript or video review was needed to clear things up. After some back and forth, the parties reached an agreement. Montes would stand on his guilty pleas. The fines would be the statutory amounts $800 on count 1, $100 on count 2, with concurrent jail sentences reduced to 6 months and 120 days, respectively, and a year of non-reporting probation. Montes confirmed he worked at Rose Saves Traffic Systems and could pay $700 of his financial obligations immediately, with the remainder due in 30 days. The judge accepted that plan, tacked on court costs and attorney fees, and laid out the simple probation terms: pay the balance, violate no laws, and the case closes without further incident. The atmosphere was steady, with Judge Webster making sure the record was clean while still accommodating a practical solution that both sides supported. It was a nice example of how the court can untangle a messy procedural history and bring a case to finality without unnecessary drama. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.